Peter Klein says, I'll probably lose the appeal, which you're basing on literally nothing. Would be funny if I win the appeal and then failed when Colorado law was applied. I mentioned that as a possibility, winning the appeal and failing when Colorado was applied. Again, that would have to ignore the summary judgment standard. There are no material facts in dispute. The only material fact, as acknowledged by the judge, by the way, the only material fact that is missing is Montagraph's alleged damages. And the only reason that is missing is because Montagraph hasn't provided them. And he's the only one with access to that information. His lawyers and he have not provided it. Why? I don't know. They wanted discovery for that information, which is silly because they don't need discovery for that information. They're lying about all of it. They're lying about that. But Montagraph should be able to just produce his damages. His YouTube analytics exist. Any business contracts that he may have lost exist. And any medical bills that he's had to take for his very serious therapy that he's going through, that he definitely wasn't going through beforehand because he's definitely not crazy. All of those exist, and he has access to all of them. I have access to 0 of them. He has not produced that element. That's up to him to produce that. But we haven't disputed any of them. They haven't been raised. None of this has been raised at all. So the status of the case is if we win on this appeal, it gets remanded to the district court to apply Colorado law. If my lawyers are correct, which would mean we win, then Colorado law is applied as a summary judgment standard, which means that there are no material facts in dispute. And therefore, it's a matter of law on the ruling. Have they met the elements to sustain this, or can they show a material fact in dispute? Where have we disputed a material fact? Anywhere in this case. And if you don't understand how important that is to summary judgment, I don't know what to tell you, but the who, me, saying what I said about who, Montagraph, has never been disputed at all. We've accepted all of them. We just argue that under the law, they're not defamatory. They don't meet the requisite level of liability. They're non-defamatory opinions. All of that is a legal argument that can be settled at summary judgment. But you have to have the material facts in dispute or not in dispute. They haven't raised any material facts that are in dispute at this point. If it goes back, summary judgment should apply, and I would think would weigh in our favor. But it is possible that the judge would say summary judgment applies and weighs in Montagraph's favor. No material facts are in dispute, but this is legally defamation, and therefore he's entitled to the damages he asked for, or some level of damages. Okay, maybe that's the outcome. We'll see. I have never taken this crazy stance on. I fully believe everything I said is well established online, that I have had plenty to reasonably base my assertions off of, based not only on 10 years of history on Montagraph online, but also my own deduction from his own statements. These are my opinions. They're actually worded as opinions if you read them. But hey, it's up to the court to apply that standard and to apply law. As of right now, they simply said summary judgment was not relevant at this time under Minnesota law. It is relevant under Colorado law, though. So if we win on Colorado law, goes to summary judgment. If we lose on Colorado law, discovery happens, then we ask for summary judgment again. If we win on Colorado law but lose on the summary judgment, then it will go to trial. Well, discovery and then trial. So I don't know the outcome. I've never suggested otherwise. A lot of other people have taken some very chest puffy opinions on this, and they ignore all of the legal standards, and they also ignore all of the lack of legal rulings on this particular issue. And there's a reason they have, Peter Klein. Because like you, they have literally failed to remove their subjective dislike of me from their analysis. Because Peter Klein, it's pretty obvious that you're mad at me for something, or you think I'm bad for some reason. Unrelated to this, you have not objectively reviewed this case. You probably don't understand what you say, and I can tell because you just cited defamation per se. You think that defamation per se is an automatic win. Defamation per se is not an automatic win. Defamation per se just means one element one element of defamation is satisfied, which is damages. There are 5 elements. All of them have to be satisfied for a case to move forward at summary judgment. Keep going, though. I'm sure your legal discourse from Kiwi Farms will get you all of the joy in the world, and you can go ahead and celebrate your victory. I am watching this play out because I have no idea. I believe I'm in the right. I've been wrong plenty of times in the past, and so have several other people. You believe I'm in the wrong, but your reasons are pretty obvious. So cheers to you, brother. Enjoy it. You can say it all day, and we'll see. Should I lick the bottle for you? Will that make you happy? So silly.